texted him, so I texted him and said he was out of town.
Oh, yeah?
And he had just gotten in town.
Okay.
Well, I don't say hi, every now and then. She pops her goes, hi girl, how you doing?
Who?
Nicola.
Cool, okay.
Nicholas was with us.
Okay, folks, let's do the statute. And then we can get on to something I like better. Easements are, I think easements are more fun than landlord tenant. We'll see. We talked about this statute has three parts. Part one was a couple of basic terms that relate to commercial landlord-tenant relationships. Part three is self-storage warehouses. And this is part two that we're going to take a look at that is attached as an exhibit, or actually an incorporation into this lease. This lease incorporates all the terms of the statute. This is the heavily regulated area, as I mentioned to you, that Florida has legislated very heavily in residential landlord-tenant situations. This is the Model Act, the Model Landlord-Tenant Act as adopted in Florida, with a few Florida changes. The section 8341 says this applies to the rental of a dwelling unit. 8342 tells you a couple of things it does not apply to. It doesn't apply to a hospital or a prison or a dormitory. And it does not apply to transient occupancy. It does not apply, interestingly, and I don't know why it ever would, but to occupancy by a holder of a proprietary lease or occupancy by an owner of a condo of their own unit, obviously. So, it defines a dwelling unit, which is what we're talking about here in section 2A at the bottom, as any structure that is rented for use as a home, residence, or sleeping place by one or more persons as a common household. So that's pretty much every residential lease. It's going to use the term premises at the top of the next page, like we talked about in the lease. The statute likewise uses premises. Subsection 12 of the definitions, security deposits. Monies held by a landlord as security for the performance of the rental agreement, including but not limited to monetary damage to the landlord caused by the tenant's breach of lease prior to the expiration. What that means is it's not limited to a damage deposit, a breakage deposit. This is for any tenant's breach prior to the expiration of the lease. Unconscionable conduct in the middle of the page. Unconscionable is a term you may not have seen before. Unconscionable has been defined by the courts as any conduct that shocks the conscience of the court. Other courts have said unconscionable means anything that is grossly unfair or inequitable. And what they're saying here is that any provision that a court finds to be unconscionable in any rental agreement, the court can refuse to enforce the entire agreement if it wants to, or merely refuse to enforce the unconscionable provision. We talked earlier about the materials made a big deal out of a term tenancy as to whether it's month to month or week to week or year to year. They're defined here in section 8346. The cancellation provisions we talked about are near the back of the statute. 8347 is important because it says if you put any of the following things into your lease, they are void. You may not put in there any provision that purports to waive the rights or remedies or requirements of this statute. So you can't have a tenant say, never mind, the statute doesn't apply. The second part is not quite as relevant. Attorney's fees, 8348, top of the next page. We talked about the prevailing party attorney's fee clause, and what this provision says is that any time an action is brought to enforce the terms of a rental agreement, that means by landlord or tenant, either one, the prevailing party shall be entitled to recover its fees from the non-prevailing party. So the clause that we saw in the lease is identical to what the statute said the law would be, even without the clause in the lease. 8349 talks about security deposits. Talks about in 1A, you have to be held in a separate account, non-interest bearing, or B, if you earn interest, you have to pay 75% of the interest to the tenant. C is interesting. C used to work really great. C used to say you could post a security bond of $50,000, and then you didn't have to hold your deposits in escrow. But if you do, you got to pay interest of 5% to the tenant. So of course nobody posts a security bond anymore because it ends up costing them 5% interest on the money they hold. Understand that the bold print language here, which is important to know, if you should ever be a landlord or if you should ever be a tenant, what they boil down to saying is simply, if you're the landlord, if you intend to impose a claim upon tenant's security deposit, you have to give written notice of that to the tenant within 30 days after the tenant has moved out. If you don't, as a landlord, you have waived your right to impose a claim on the security deposit. 30 days to give a written notice. Tenant has 15 days after receipt of the written notice to respond disputing. If the tenant does not send a written dispute response, then the tenant is deemed to have agreed. So those two time periods are important because they are without exception. There are no excuses. Okay. Next page is simply more provisions about the notices you have to give when you're opposing a claim on security deposit. It gives you a form. It talks about how you serve notice, etc. if you're opposing a claim on security deposit. The next page, which is page 12 of 18, section 8351 at the top of the page. Landlord's obligation to maintain the premises. We talked about that. Simply, the landlord is obligated to comply with all requirements of building, housing, and health codes. And there are not many others. Where there are none, it provides what the landlord is obligated to repair. But there are housing, building codes anywhere you're going to be in South Florida, county or city, one or the other. Now, section 2A says, and this is interesting, other than for a single family home or duplex, the landlord must do the following: extermination of mice, rats, bugs, provide locks and keys, clean, safe common areas. That's obviously in a multifamily unit for the halls and stuff. Garbage removal, outside receptacles. Must make sure the functioning utilities for heat during the winter. That's the landlord's obligations to maintain the premises. Tenant's obligations are 8352, about 2/3 of the way down the page. Tenant shall likewise comply with the applicable provisions of the housing code, but there aren't any that really apply to a tenant. And it just goes on to basic clean and sanitary, throw out your garbage, clean the plumbing, etc. The landlord's access to a dwelling unit. We've said that by the very nature of a lease, landlord delivers exclusive possession to a tenant, has to stay out, but this gives the landlord the right to enter on reasonable notice to preserve the premises or to inspect the premises. Interestingly, section 8354 says that the fact that a civil action is granted under this section, which means the right to sue for damages, does not preclude prosecution for a criminal offense relating to the same leased property. That's got to mean for tenants' intentional destruction of premises, of property. That's got to mean for landlords trespassing. Wherever criminal penalties will apply, this is not intended to take their place. 8355 provides that if either landlord or tenant fails to comply with the provisions of the rental agreement or this section, either party may sue to recover damages for the non-compliance. And as we've seen already, and to recover attorney's fees for the cost of prosecuting a lawsuit. 8356 talks about the termination of the rental agreement. This is mostly for tenants' failure to pay rent. The provision, what the steps that the landlord has to go through in order to terminate a lease. At the top of the next page, 14, is the famous 3-day notice that you hear about, that landlords are required to post on the door of a tenant's unit for failure to pay rent for a 3-day notice that the lease is going to be terminated. 8357 is that provision we alluded to earlier that says, for example, where you have in 3, where you have a month-to-month tenancy, you have to give 15 days notice to kill it. If you have a week-to-week tenancy, you have to give a week's notice. Year-to-year tenancy, you have to give 60-day notice. These are something, when you need to know them, you look them up. Bottom of page, 8358 is a provision I mentioned to you before. Holdover tenant, in the very last line. When a tenant holds over, the landlord may also recover double the amount of rent due on the dwelling unit for the period during which the tenant refuses to surrender possession. That's just intended to be a club to make the tenant get out when he's supposed to get out. Next, section 8359 is really a page and a half on litigation, talking all about the court procedures for a landlord to recover possession of an apartment, the terms under which the court will have a sheriff dispossess a tenant. At the top of the next page, subsection 2 on page 16, is a provision I mentioned to you about you may not withhold. It says, in any action by the landlord for possession of a unit, if the tenant interposes any defense other than payment, then the tenant shall deposit into the registry of the court the accrued rent as alleged due in the complaint. When due. That means as the case continues, monthly when due. So for a tenant to raise any defense to a landlord's suit for eviction, other than claiming I paid the rent, you got to keep paying the rent to the court registry. Retaliatory conduct is prohibited. Retaliatory conduct is a landlord taking retaliatory action against a tenant who has complained. This talks about if a tenant basically calls any housing agency or a governmental agency, or creates a tenant unrest or a tenant organization, or complains, the tenant may not be discriminated against by the landlord by having him increase or decrease his rent or his services. And some interesting prohibited practices on page 17, including one of my favorites from the old days. 8367 down in subsection 5. I was told when I first started practicing law that the most effective thing that landlords could do to collect the rent when tenants weren't paying the rent was they'd merely go around and remove the front door. And it worked. And very quickly, tenants came running to landlords to get their front door back. And subsection 5 prohibits this as a practice, prohibits landlords from removing the door or the locks or the windows in order to compel a tenant's payment of rent. In addition, under subsection 2, they may not change the locks either. So these are prohibited practices by a landlord, and may not terminate utility services either, if the landlord provides utility services.
So what is now the most effective way?
What they're trying to tell you to do is to sue. They want you to sue.
Yeah.
That's the whole point. What they're trying to do is prohibit self-help here.
Yeah.
Self-help,
All right.
that's the word.
Okay. But to answer your question, what is the most effective way? I'm not sure there really is a good effective way.
You talked about the sheriff.
The good ones have been removed here, the ones that really work.
You talked about the sheriff's office.
I'm sorry?
The sheriff's
Oh,
office.
yeah, exactly. You
That's
gotta get a
effective.
court order. Basically, you gotta get the judge to order the sheriff, then the sheriff goes out and puts a tenant out. In other words, there's no situation where you as a landlord ever are gonna be able to go grab a tenant and remove him from the property.
Right.
If you do that, you set yourself up for assault, battery, all kinds of
Yeah.
stuff. Basically, you get the court order to have the tenant evicted, and that is done by the judge sending the sheriff out there, and the sheriff moves the tenant out and puts the tenant's stuff out in the street. And that's pretty much the end of the chapter. So that's the Florida Residential Landlord Tenant Act. It is pretty extensive, and if you end up owning and leasing out or managing for someone else residential apartments, you need to get rid of this. Okay. I'd like to move to chapter 9, if that's all right. Chapter 9 is easements. An easement is a non-possessory interest in real property. It's the irrevocable right to use someone else's real estate for a limited purpose. And so in a prayer class, somebody said, well, what does it mean? And let me just show you simply what it means and draw a picture of an easement, if I can see what they did with them. This is truly amazing if this is going. Fred said somebody is coming around stealing these things. He put 4 of them in here last time we had a class. And
It's gone.
I thought there were a bunch even when we
And
walked
I
in
had
this
it
morning.
obviously earlier, and I erased with it, and left it sitting right here, and while I was out on lunch break, I think somebody took it. He said,
He said
somebody
it's
must be
liquid
selling
gold.
these things or
He
something.
said it's liquid
Yeah.
gold.
It was sitting right here with the eraser.
I'll sell you one for $3.
Well, then I'm not gonna draw a picture of an easement.
You should share.
It's in the book. We have good pictures in the book.
I could finger paint it.
That's funny.
That's really amazing.
It's upsetting.
Hey, sir, you could check the video.
I'm sorry?
Oh,
Yeah, right there.
The video's going.
No, you
Oh,
didn't.
we'll
Oh, you mean what? You know what?
We'll get to the bottom of
It
it.
was on. It was on.
Let me tell you a good bad story on that. This morning, I got here early and turned the camera off because I was going to sit for 15 minutes, and I forgot to turn it on. So the morning session is not recorded. Hopefully this is big right now. It says record. I've already written a text to Fred and apologized. But you're right, if that had stayed on, that would have been a hoot to watch and see who came in and got that thing.
Oh, yeah.
Because honestly, it was,
Oh, it's an
it was right there.
investigation.
I cleaned the board with the, the
She
cloth
said
and all that
same
stuff and was ready to
operation.
draw some more
Absolutely.
pictures.
We'll do it again. Instead of just laying out real nice and orderly,
That's what we
5 or
need to do.
6.
Instead of trap, yeah, okay.
Yeah.
Well, really, the trap gun would be the way to go on that.
Oh.
Wow.
All right.
You been stealing son of a.
All right.
And our stuff
You know
was
what?
in here. That's crazy.
Because this is important, if y'all have the text with you, you know what? Excuse me a second. I'm going to go next door and see if maybe they just disappeared to the next classroom.
That is very, very bad.
Yeah, that's
And,
kinda traffic.
okay, so last time Cordy gave him a whole pack of 4,
Yeah.
brand new one, and he didn't use it, he, you know how it was in pain or whatever, he had a cane?
Yeah,
He left it here.
yeah. And
He
I
took it.
I saw a pack before, I thought this was.
Right, and he gave it to him, he bought it for half.
Yeah.
And then he goes, he's like, well, that's like going with gold around here.
Oh, there it is.
Hey, you left it there.
Huh?
You left it in the bag.
That's where it
That's where it is.
Anyways.
is? Thank you. I was getting nervous, I better take a look at my wallet, because we're all over from it.
I was gonna say, all our computers are still here. If that's the only thing they took, we made out.
That's it, we'll blame the machines, yeah.
Yeah.
All right, now let's talk about an even. Okay. Let me give you an example. Say I own this piece of property. And there's a road out here. There's a road. This piece of property is on the road. I decide to sell you, and you'd like to buy the back half here. Okay? I'm going to keep the front half. I'm going to sell you the back half. The question is, simply, how are you going to get to the road? Somebody else owns this. Somebody else owns this. Somebody else owns this. How are you going to get in and out of it?
Landlocked.
And this is real important. This is the concept of an easement we're going to talk about. But the how you're going to get in and out of there is a concept called access. And we're going to talk about access at great length in 2 or 3 places throughout this chapter. But the important thing is, to get in and out of here, you need an easement. I can give you an easement over my east 10 feet, or my west 10 feet, or my middle 20 feet, or whatever. But the point is, you only own this, and that's a public road, and you want the right to use, you need the right to use my piece of property for a specific purpose. This purpose of this one is access. For ingress and egress to get in and out of the property. This is called an easement. Okay. And it's the kind of easement we're going to talk about first here. There are 2 kinds of easements. There's an easement appurtenant, which we're going to talk about at some length. And then there's an easement in gross that we'll talk about a little bit later. An easement appurtenant means an easement that, I know you know the word appurtenant means kind of attached to or goes along with. It's an easement for the benefit of a certain parcel of land. That easement benefits parcel X and is an easement appurtenant. What that means is,
Isn't it for the right of a person to get a benefit?
no.
No?
An easement is the right for a person to use a piece of property.
Okay.
An easement appurtenant is an easement that benefits a certain piece of property.
Okay.
Any easement is a right for a person to use property. An easement appurtenant is an easement that's tied to a certain piece of property. This easement is only usable by and from this piece of property, notwithstanding who gets to use it. It's only usable by and for this piece of property. And What an easement appurtenant means is, and then we're gonna go back and define the two estates and stuff like that. What an easement appurtenant means is, if I sold this property to you, and I separately, or in the same deed, granted to you this easement over the east 10 feet to get in and out of here, this easement becomes appurtenant to this piece of property. And this becomes an easement appurtenant. And what that means is, any time the title to property X is transferred, the easement goes with it. The easement is appurtenant to the piece of property. The easement is attached to the piece of property. Anytime X is sold or mortgaged in the future, whether or not that subsequent sale or mortgage mentioned the easement goes with it. The easement then, and because an easement is irrevocable, easement is forever. So once that easement is created and attaches as an easement appurtenant to this piece of property, it becomes a part of this property and is transferred with the title of this property, whether it's mentioned or not. So that henceforth, whenever X is conveyed, the conveyance of X includes the easement. In addition, whenever Y is conveyed, Y is subject to the easement. Y always has the easement on it. The other piece is subject to the easement forever. This is benefited by the easement forever. This is subject to the easement forever. And what that creates is two parcels. One is called the dominant parcel, or the dominant estate, and that's X. And one called the servient estate, and that's Y. And they kind of make sense. The dominant estate is the one that gets the benefit of the easement. The servient estate is the one that's subject to the easement, that has the easement sitting on it, that is burdened by the easement. Okay? We're going to use those terms going forward. Now, easements do a lot of other things other than access, but I want to keep emphasizing over and over again, and we're going to talk about them mostly in the concept of access. There is no more important use for an easement than an access. It is the most significant and the most beneficial thing an easement can do for a piece of property. Now, I want to talk for a moment about a very special, limited type of easement that really, in a sense, is not about easements, but it's a concept called a party wall. A party wall involves an easement, but say we have a piece of property here. And you decide to build on it a duplex. And there's a wall down the middle of the duplex, like most duplexes, and they share that wall. Normally what would happen here, if a duplex owner owns the whole thing, it really is not, if he owns both halves, if an individual owns both halves, there are really not two parcels involved here. But what often happens is, you then convey the properties like this, so that this wall, it goes down the center of the unit, sits right on top of the property line. That's called a party wall. A party wall is a shared wall that two buildings use that sits right on top of the dividing line that divide the parcels. So to have a party wall, you got to have two owners. And you got to have a property line that goes right down the middle of the wall. what a party wall agreement says is we both agree to maintain the wall, because if either one of you takes down that wall, it wreaks hell on the other building. So you both agree to maintain the wall, and you agree to let the wall sit right on the property line. You each agree to maintain your half and not to take down the wall. But here's what's going on. The portion of the wall that sits on this property is sitting on an easement appurtenant for the benefit of this property. Similarly, this portion of the wall sits on an easement which is appurtenant to that piece of property. So the text decides to bring the whole concept of a party wall in under the pretext of the discussion of easements appurtenant, because it does involve an easement appurtenant for the limited small portion of half of the width of a wall that sits on the other guy's property. That's a party wall. There are party wall agreements that you'll, in that situation, you'll sometimes see an agreement where two owners each own half of a duplex. You agree to share the party wall, you agree to paint the outside at the same time, you agree to maintain the roof together, because there usually be one roof going across the top of the thing. There are all kinds of provisions that would be in a party wall agreement, but the essential part of a party wall agreement is you're sharing a party wall. You have one shared wall, and these are all over up north. You see what we call zero lot line buildings up north everywhere, where property after property is built like that. And each separating wall between two owners sits half on one side of the property line and half on the other. And they share the wall. In all those cases, it's called a party wall, a shared wall between two adjoining owners. And it involves a limited use of an easement appurtenant under the side of the wall on the other guy's property. Okay, now, back to easement appurtenant. We said there were two types of easements.
I mean, sir, what's the point of that? I mean, the fact that both.
The point of that is you need to know what a party wall is, and they happen to throw it into this chapter.
But I mean, you can't sue the other guy for
You can't want
not keeping up with his side of the wall, or not painting his side of the wall, or doing.
No, you really don't care an awful lot whether the guy paints his side of the wall or not. If the guy takes down the wall, he just took down your wall too.
Right.
That's the problem. What a party wall agreement says basically is neither of us will punch holes in the wall or will remove the wall because we're sharing. That's what a party wall is all about.
And can you sue the other person if they do?
Oh, absolutely.
Okay.
Yeah, yeah. You surely can. And you get into situations where what happens if there's a fire on one side and the wall burns down, and who rebuilds it, and who has to pay for it, and stuff like that, based on whose fault was it, whose insurance policy, etc. Usually it's a block wall, though, and usually a fire's not an issue. There are a lot of party walls around, an awful lot. And the point of it, as it relates to this chapter, is meaningless. It has really nothing to do with this chapter, but they threw it in there, but someday you'll need to know what a party wall is. Okay. The other type of easement is an easement in gross. Now what that is an easement which is a right to use someone else's property, but which is not connected with any adjoining piece of property. Under our easement appurtenant stuff, I could probably construct an example, but it would be difficult, where the properties are not adjoining. Easement appurtenant is virtually always going to be adjoining properties. An easement in gross does not involve a second piece of property at all. It's like a utility easement. The book gave an interesting example of a shortcut as an easement in gross. The right to use a shortcut across somebody else's property as an easement in gross. I think utility easement is probably the best, most likely. It's not it's not in favor of any adjoining piece of property. It's in favor of FPL that may be 20 miles away or 50 miles away. And obviously, a utility easement is if out here along the street, the owner of parcel Y gave a utility easement of the north 5 feet for sewer lines, for power lines, for underground utilities, water lines, usually they're for utilities. And the point is that that type of easement, being an easement in gross, has nothing to do with an adjoining parcel. It's a right to use a right to use this piece of property in favor of persons, entities, elsewhere. Okay, those are the two types of easements. Remember also this one concept we talked about with the dominant estate and the servient estate. There is no, in the utility easement we talked about, there is no dominant estate. There is no other piece of property that benefits from the easement. But there is a servient estate. The property that's burdened by the easement again. In both cases, this property, whether it's this or this, are the servient estate because they are the property that's burdened by the easement. Okay. How do you create an easement? Well, in general, there are two ways. The first way, and I'm going to mention the two just to distinguish them and see if we can understand the difference and then explain them more in depth. One is what's called by expression, which means to me intentional, and the other is creating an easement by implication. And that's something that's implied, not intentional, but implied. The intentional action to create an easement, which is an easement by expression, is either a grant or a reservation. The materials call them an express grant or an express reservation, but it's a grant or a reservation. These are the intentional ways of creating an easement. You either grant an easement to someone, or when you're conveying a parcel to someone, you reserve an easement. Back under our factual situation. If I own the whole thing, okay, I can sell you X, and then I can grant you the easement that would be normally done in the same document. So in this deed, I would sell you the south half of the property, and I would grant you an easement over the east 10 feet of the north half of the property, which I'm keeping. That's a grant. This is the grant of an easement. In a deed, you don't have to do it with another piece of property. You could simply give a deed where you say to a guy, I give you an easement over the over the east 10 feet of the north half of this property. That's the grant of an easement. The other way is by reservation. This is a grant. The other way is if I own this whole piece, let me think here now. If I own the whole thing, let me come up with a better, yeah. If I own this whole piece of property, street's out here again. If I want to sell to you this north half, this time I'm going to sell you this. I'm going to retain this piece down here. So I'm going to give you a deed of X. And in the deed, since I'm keeping this piece, I'm going to reserve an easement over the east 10 feet. So what's happening here is I've sold you this and I've kept this. But as a part of my sale of that to you, I reserve an easement over the east 10 feet. I didn't grant an easement. I sold something and reserved an easement. That distinction make sense? Okay, great. Basically, you either give one or you give something else and keep one and reserve it. That's the two ways to create easements by an express action or an intentional action, is either a grant or a reservation. Now, there are a bunch of implied easements. Implied easements are easements that are created perhaps by action or by circumstances or by facts, but they're not something that you do here in a written document. These are things that you actually do in a deed. To create an implied easement or an easement by implication, the first type would be an easement implied from prior use. If I sold you this, but I didn't give you this easement. But for years and years and years, everybody had used this piece of land over here to get to this back piece. That would be an easement implied by prior use. If for years and years this property had been used as a road, let's say there was a dirt road on here and it had always been used to get to this back piece, and then I sold you this back piece, an easement can be created by the implied prior use of this for the benefit of this. That's prior use. The second that relates more directly and importantly to the important concept I want to discuss of access is an easement implied from necessity. And this is also called a right-of-way of necessity. If I sold you this piece of property and I kept this, I didn't grant this easement. This had never been used as a road. You realized you had bought a piece of property that had no access whatsoever, which in a legal concept makes the piece of property worthless. If you can only get to a piece of property by a helicopter, it's no good for using it for all the purposes for which we use land, including leasing it out. If this parcel is landlocked, the courts say that it will create a right-of-way or an easement of necessity to give a landlocked parcel some way to get in or out to a public road. Now this is what we call a fallback. Whoops, I forgot to get an easement. when I sold you X, the first thing you should have said to me is, okay, how am I gonna get in and out of here? Are you gonna give me an easement over your parcel to get me in and out? But if you didn't think of that, and you bought parcel X from me, you can go to court, and I won't give you an easement, and I won't let you cross my land. You can go to court and say, Your Honor, I need an easement of necessity to enable me to get in and out of my parcel X. And courts will find a way for you to get in and out. They may not give you what you're looking for, and that's why you don't really want to fall back on this concept of I bought a landlocked parcel. Number one, you don't want to have to go to court and prove it up and pay the expenses of trying to get an easement determined by necessity. But secondly, the court may not give you what you're looking for. The court may say, yeah, that'd be nice. Maybe we could give you right-of-way necessity out here, but we think we'd rather let you go four miles down here and come to this road down here. And they might give you way out this way, which is not what you want. You don't want to fall back on an easement of necessity to get access to your property, but at least the concept is there in case you didn't get an access easement when you got a landlocked piece of property. But that's an easement that's implied by the necessity of having a way to get in and out. There are easements implied from plats and maps. And what this is if you buy a piece of land that's a lot on a map, and there are roads on that map, even if they're not dedicated roads, even if they're private roads, the courts will give you the right to use private roads shown on a map for access because they were implied to be used as roads on the map. The more often way that they're created, the roads on a map or a plat, is by dedication. And this is strange that the materials set forth dedication as a type of implied easement, because there's nothing more express or intentional than when you dedicate roads. It should very much have been set forth up in the upper section where we talked about the intentional ways of creating an easement. When you record a plat, I'm sure you'll know that if you record a subdivision plat with a whole bunch of lots in it, and all these lots going through the block here, each of these is a separate residential lot. The governmental bodies, when you record the plat, are going to make you dedicate the streets. They're going to make you dedicate East Street and West Street and North Street and South Street. They're going to make you dedicate those streets to the government. To the public is what it's called. But actually title to those passes to the municipality or the county, whichever you're in. And these roads become dedicated public roads. They become owned by the governmental bodies and maintained by the governmental bodies. But the point is that makes them public streets. And then you obviously have ways to get in and out of the property by whichever road you happen to front on. These are easements, but they're dedicated, and dedication is an action on a plat where the developer signs a plat and it says, I hereby dedicate North Street, South Street, East Street, and West Street to the public for the benefit of public use as public roads. That's another way that easements are created. It's again listed in the materials as an implied way to create them. I think it's an intentional, but it's another way that road easements are created.
So that you said the developer does that?
Well, whoever's recording the plat does it, and that's usually a developer. Whoever's platting property,
Right.
you want to distinguish a developer really from a builder. I mean, a builder and a developer are not necessarily the same thing. You could have in that block you could have 3 separate builders who were each building houses on several different lots. But the developer is the guy who recorded the plat of the entire subdivision and created the subdivision. And since he's a landowner, the person that I'm talking about who does those dedications owns that entire box and creates the streets and files the plat and then dedicates the streets to the public as a part of it, but he was the owner of the property at the time he did it.
But the dedication is a separate document? Or
It's
just-
usually set forth right on a plat.
Oh,
Usually
okay.
right on a plat, it says, I hereby dedicate all roads shown on this plat to the public for the proper
Oh.
use of the public for thoroughfares and stuff like that. Okay. Easements can also be created by prescription. Prescription is analogous to adverse possession that we're going to talk about in a later chapter. Prescription means that you are wrongfully using a piece of property belonging to someone else over time. Continuously, adversely, openly, notoriously, these are all the terms variously used by the courts. And that whole concept of adverse possession where you can obtain title to a piece of property, or an easement by prescription where you can obtain the actual right to an easement by wrongful use, is all based upon the concept that if you own a piece of property and you let somebody else use it without giving them permission and don't do anything about it for a certain period of time, they can obtain rights in that piece of property.
What period of time is that usually?
In Florida, it's usually 7 years.
Okay.
It mentions in the materials, I think, a bunch of different terms. Some are longer, some are shorter.
Did you say that you lose the right to claim? Is that what?
You lose the right to stop them from
Okay.
using it. What this means is if I have a ranch and you have a ranch, and for 7 years you just plain old trespass on my property by coming down that boundary to get to your piece of property, and I do nothing about it. It's clear that I didn't give you the right to do it. There's no permission. You can't be hiding it. It has to be open, notorious, adverse, meaning you're keeping me from using it, you're using it. If you do that for 7 years, that can create what's called a prescriptive easement. I'm Florida for 7 years, different terms in different other jurisdictions. And that can give you by law an easement that I can no longer stop, that I didn't consent to, that I didn't grant. You are basically a trespasser, and if you trespass regularly, openly, notoriously, for a certain period of time, that trespassing will ripen into, in this case, an easement by prescription, which means your easement becomes irrevocable. In a broader case that we'll talk about in another chapter, adverse possession, you can actually end up owning a piece of property. Yes,
So
ma'am?
you're talking, are you referring to like the squatter? Is that the squatter thing where?
A squatter, did you say?
Is that the term?
Well, a
I'm looking for the
squatter-
term for like-
Yeah, a squatter is a person who trespasses regularly, I mean, continuously. A squatter is more applicable to the other concept that we're going to talk about later, which is called adverse possession, and that's where you actually end up owning a whole parcel. What we're talking about here is merely gaining an enforceable easement, but not gaining ownership of the property. And so a squatter implies somebody camping out and living on a piece of property. What we're talking about in an easement sense is the right to cross property and go back and forth across it, as opposed to owning it. But it's kind of like squatter. In both cases, we're talking about a trespasser who didn't have permission, but who didn't do it in secret, who did it in such a fashion that the owner could observe it and didn't do anything about it.
So do you have to prove that the owner knew about it and could observe it?
Yes,
It shows
you have to-
not
you
doing
have to.
it?
Well, here's what will happen in a situation like this. After 8 years, the owner will decide to stop this and will go fence you off.
Mhm.
And then you, as the person who used the easement, come into court and try to prove, wait a minute, for 7 years, I used it by prescription, and that gives me the right to continue to use it and have the court give you an order creating an easement by prescription. But that's how it will come to a head, is somebody tries to stop it. And in all these cases, that's how they really happen, is when somebody tries to cut you off, and then you have to come in and prove your rights before a judge. You get an order that gives you the right to do so.
So if I bought a bunch of land for hunting, let's say, and, you know, from my access point, I can access all of it by foot, but there are parts of my land I just don't go to, and somebody else routinely hunts from that corner of the land that I just can't observe. Later on, I do some tree clearing, find a tree blind there, say, whoa, this isn't any good, I'll post trespassing, you know, electric fence, automatic rifle system, you know, whatever. Not any of that.
No, I
but-
understand what you're, I
but,
know where you're going. Are you,
So does that person now have a right to say, whoa, I've been using this for 8 years?
You didn't see them. If you didn't see
If
them,
I-
you're not gonna tell them.
conceivably.
Okay.
It had to be such that you could observe it, is what the cases say, and I'm not sure whether in
That
this
could or
situation,
was proven to be able to?
you are, the law imposes upon you as an owner of a piece of property that you're supposed to go check the property.
Okay.
And you're supposed to observe what's going on. Things that are visible on a piece of property, you're deemed to be on notice of, whether you go look at them or not.
Okay.
So the law deems you to be on notice of the fact that the guy was using your property, whether you happen to be out there and see him or not. Sometimes that's not feasible if you own hundreds of thousands of acres to see what's going on in every little minutia. But this gets to be a much bigger factor. And then another chapter we're going to talk about, which is adverse possession, where under that situation, that person can end up becoming the owner of the entire parcel. And that's when it's much more significant. We're talking here about the right to cross property for a limited purpose, as opposed to the big concept of adverse possession, which is really very contentious. I mean, there's a lot of legal writers that say that this is crap and it makes no sense and there shouldn't be any reason for adverse possession. There are other people who say that if you own a piece of property and you never see it or for 7 years, but under our tests, under our other tests of adverse possession, there's questions of who's paying the taxes and who's maintaining.
Sure.
And there are other issues involved. Here it's just plain old walking across a piece of property, which is obviously much more limited.
Okay.
So we're talking about some things like easements and walking, but what about like the easements for easement in the grows, when you're talking like, I mean, setting up a utility line?
Well, you don't usually build a building under simply an easement right. Usually you own a piece of property before you build a building on it.
Correct.
You could theoretically give somebody an easement over your piece of property for the purpose of them building a building on there, but most people wouldn't build a building without knowing that they actually own the piece of property. So I don't think realistically you're gonna run into that situation. I guess it's feasible, but I just don't think practically.
Well,
it's gonna
I'm
happen.
thinking like, if somebody built a building and then just didn't ask the adjacent owner thing and just ran a line, a utility line through their piece of property, and then 7 years later, it's an easement.
Well, see, that's a lot of the adverse possession stuff we're gonna get into. Where the building situation often happens is when a building is located improperly. Where I'm trying to build a house here, and and by mistake, I build it a foot or two by surveyor mistake of mistaking the foundation and therefore laying the foundation by accident, end up with a little bit of my building on your piece of property. Then we start to run into all kinds of litigation issues of whose building is it, who owns that portion of the building. And that's why you're going to see we'll run into when we get into questions of surveys and stuff like that. When you buy or sell a piece of property, when you buy a piece of property particularly, if you were buying this piece of property thinking that you're buying this house that's on there, you sure as hell need to get a survey of this piece of property to make sure that the house that you think you're getting actually is located on your property. Because if it's not, then you're buying into this lawsuit. You're the owner, and when all of a sudden this guy realizes you're 2 feet over under his property and he says get it off, or he comes and takes it off, and you bought into a lawsuit situation. So these type of things can ripen into ownership, and that's when you really got a bigger problem. But that's when you get into the question of adverse possession. At this point, we're doing it only on a limited basis of an easement, of not placing a building there permanently, but we're just talking about walking across a piece of property for access purposes. And to that extent, I don't think you're going to run into the building issues, but we will when we get into adverse possession. But again, it's usually by accident. Usually adverse possession of a building on the wrong piece of property is because somebody's put it in the wrong place. It would never, rarely would you go out and risk, in other words, think about it. Would you risk building a building on my piece of property here and hope that and spend all the money to build that building and hope that for 7 years I'd never notice it and go take your building? And then maybe that you're, having done so, would ripen into ownership. As far-fetched as that is, in addition, under adverse possession law, if you did that, the law requires you to pay taxes on that parcel for the same 7 years. And see, I'm going to be paying taxes on this whole parcel for 7 years. So in order for that ownership, for that encroachment or trespass to ripen into ownership, under Florida law for the 7-year period we talked about, for you to become the owner, you had to in fact to pay the taxes for the 7 years. And in this case, this guy would have paid the taxes, and that just never happened. So it's kind of it's more complicated than it appears, and it should be, because for a squatter to be able to take away title to somebody's piece of property, there should be some onerous requirements on there, and the law imposes at a minimum paying the taxes for 7 years. So that squatters usually don't pay taxes, and that's why squatters' rights rarely ripen into ownership, because somebody else has been paying the taxes. Okay, that was an easement created by prescription. There's an interesting extension of this concept when we talked about easements for light and air that we talked about earlier in air rights and water rights. Theoretically, if my parcel of land gets its sunlight from the sunlight coming across this way, and you build a building, you block my sunlight coming in. Conceivably, under an extension of this doctrine of an easement by prescription, I had an easement over this piece of property for the benefit of the sunlight coming across this piece of property. Well, the courts have said no. You can extend an argument that says, if I get my sunlight across your property, then I have an easement over your property for sunlight. The courts have said for light and air, they will not use this doctrine of a prescriptive easement in order to create an enforceable easement for light and air. And there's a good example case of this in the book that I'd like us to talk about. It's good not only because it's a good case, but to me it's of interest because it took place right down the road. At the bottom of page 207 is, I think, a real good story. It's the old Eden Rock Hotel and the old Fontainebleau Hotel next to each other on Miami Beach. And it says these two hotels within a year of each other were both built as they build them in Miami, right up next to each other. You can hardly even see between these big beachfront hotels. And 1 year after they're completed, the Fontainebleau added a 14-story addition to the Fontainebleau to make it 14 stories taller. And as it did so, from 2 o'clock in the afternoon on, all the beach cabanas and the swimming pool at the Eden Rock Hotel had no sunlight. The 14-story height addition blocked out the sunlight from 2 o'clock in the afternoon. So the Eden Rock Hotel comes in and says, hey, we, for all these years, have received our sunlight from across your piece of property. We have the right to an easement over your piece of property, over you, Fontainebleau, for the benefit of us getting sunlight. And interestingly, the trial court, this would be the Circuit Court of Miami, agreed and issued an injunction and told the Fontainebleau to quit building the 14-story addition that was going to block the sunlight on the Eden Rock. The appellate court, which means the District Court of Appeal, the Intermediate Court of Appeal that we talked about in Florida, in Miami, reversed and said, no American decision has been cited or independent research has revealed in the absence of a contractual or statutory obligation, which there isn't between neighbors, that a landowner has a legal right to the free flow of light or air across an adjoining parcel of land. There is no legal right to the free flow of light or air from adjoining land. It goes on to say, interestingly, it is universally held that where the structure serves a useful and beneficial purpose, it does not give rise to a cause of action, either for damages or for an injunction, even though it does cause injury to the other by cutting off the light and air. It goes on to say, remarkably, regardless of the fact that the structure may have been erected partly for spite, which almost sounds like there was a war between these monster Miami Beach hotels out trying to outbuild each other for spite. The court says it also affirmatively appears that there are no possible basis for holding the plaintiff has an easement for light and air, either expressed or implied, across the defendant's property or any prescriptive right thereto. And this comes up in this connection only because we were talking about prescriptive easements. So, the concept of prescriptive easement passing across someone else's piece of property and ripening into something that is an enforceable right, it's not going to work for air and sunlight. Okay. There are two more concepts I want us to talk about here. Then I think we're kind of done with this area. The first, interestingly, is about how to terminate easements. And there's nothing really significant here at all. Any right that you can create, you can terminate. Just like we could terminate mineral rights with a document, a release. We could terminate a life estate with a release. Well, we can terminate an easement with a release. I think we all kind of knew that without being told, but the materials want to tell us that that by a release, an easement that was once created can be terminated. There is an interesting concept, though, where it talks about merger. And merger means in our easement appurtenant situation, where the dominant estate and the servient estate both end up being owned by the same person. This concept of merger is going to apply in 4 or 5 different areas that we're going to talk about, where 2 different types of rights in a piece of property come together in the same owner. It therefore extinguishes the type of rights that we were talking about. In other words, in this situation, if both parties, X and Y, both decided to sell to Bob, and Bob owns both parcels, he owns both the dominant estate and the servient estate. When title to both of those estates merges into one person, that kills the easement. And that's the whole concept. That concept applies in other areas, and that's the reason I wanted to spend a second on it, in terms of other things we've talked about. For example, the life estate and the remainder. If the remainder persons conveyed to the person that owned the life estate, the 2 estates would merge, and there would be no separate estates anymore. Likewise, if the life tenant conveyed to the remainder, there would be no more life estate. Both estates would merge into a fee simple. And that's the same concept we're talking about here, but we're going to see this in mortgages. Here we're seeing it in easements, that any time the property benefited by the easement ends up owned by the same person that owns the property burdened by the easement, then there are no longer 2 separate parcels or 2 separate parties, and therefore there is no more easement. Yes, ma'am?
What if the owner Y buys X? Same thing, right? Doesn't have to be a
If you want to
different.
say?
If the owner of Y buys property X.
Oh, either one. One owner. Yeah. If X
It
bought
doesn't have
out
to be a
Y
third
or Y
party.
bought out X, what we're saying is, exactly, any way that that happened, that both parcels ended up in one owner, there is just no easement anymore because there's no
No,
parcel
servient.
benefiting from it and no parcel burdened by it either one.
I got a question for that.
Sure.
What if, what if I am the owner of Y and there's a road that goes on my property and I want to build something on that road? And so I end up buying X, but there's a house on X, and then can he now?
I'm
build
sorry,
on that road?
I lost your first step there. Excuse me. You own Y and you want to build something on top of where my road is?
Yeah, and so you buy X in order to remove that road.
Oh, sure, okay.
And you could do that. You
Oh,
could-
yeah, there is no more easement. Exactly, the easement is gone.
Now, what happens if I decide that I want to lease that house, but, I mean, I have to provide some sort of access, correct, to that house, even though I own both properties?
I missed you there again. If you do what now?
If I lease the house, so no
Which,
one-
where's the house we're talking?
On
Well,
X,
you
sorry.
now, you're telling me you own everything here, right?
Yep.
Okay, and where's the house?
The house is on X property,
I'm sorry?
the X.
Yeah, you're gonna put a house somewhere down here
Yep.
on X?
Do
Okay.
I have to provide a road to the public road from the leased house
For yourself?
for the lease, whoever
Well,
leased?
you need to provide a way in and out of the house to your tenant under your lease.
Okay.
You couldn't, I don't think that's really an easement situation.
I guess-
think that's what you're leasing to the guy. That's more of a landlord-tenant situation.
Right.
You're leasing a house, and you need to give him a way to get to the house. But I don't know that that necessarily creates an
It
easement.
doesn't have to be that road, though.
Oh,
It could be-
absolutely not. No, any
I
other
could
way.
create some
No,
side.
You could let him in this way, you could
Yeah.
let him in this way, you could let him in any way you wanted to. This really, there may or may not have ever been a paved road there, but even if there was a paved road, even if there was a paved road with guardrails and stripes and then a whole 9 yards, if the same person owns both properties, it's not a road anymore unless it ever become a public road. Once the public obtains rights in that road, then that's totally different. You know, that's like a dedicated road out here, and then you can no longer stop the public.
Okay.
Okay, so this it really is kind of overkill on the subject of how you kill an easement, but I think it was an important lesson there in the concept of merger, because sometimes when we create these different estates in a piece of land, whether they're easements or whether they're life estates, whether, candidly, even in a landlord-tenant situation, if the landlord buys out the tenant's interest, or the tenant buys out the landlord's title, the lease goes away. We have no, in all those cases, what we're talking about is taking two different estates and merging them, in which case there just aren't two estates anymore, we just have a basic fee simple. Eminent domain, I'm going to talk just for a moment here about eminent domain, because we're not going to cover the concept in a separate chapter. It is in the book, but we're not going to do it. Eminent domain is a concept where the government buys property.
So we don't have to know it?
You don't need to know it for the purposes of this course.
Okay, good.
But I want you to understand what the concept of eminent domain is as it relates to easements. Eminent domain, of course, is where the government, the sovereign, has the right to take land for a public purpose anytime it wants to. The lesson in this is simply that if the state who owned this road decided to acquire, let me come up with a better example. If the state eliminates an easement, the point is that an easement is a compensable estate that the state would have to pay eminent domain dollars for. Now, I'm trying to come up with a good example. And I don't think it fits our facts into the situation here, because a widening of that road isn't the type thing that we'd be talking about here. Let me try to think of a better example.
Usually, isn't it for like a railroad or a highway or, you know?
Yeah, those are eminent domain, but what I'm saying is, when they take a parcel,
So
they have the right to eliminate any easements on the parcel. So if somehow a utility company were to come in here and buy out this property, in so doing, it would kill this easement. This guy, who has an easement of value, can be compensated for the loss of his portion of the easement here. That's really the only lesson in this, is not so much to understand the law of eminent domain, but to understand that easements are sufficiently irrevocable and permanent and valuable, such that if the government takes one away from you, you get to be paid for it. Okay, one last concept in the chapter here is, in understanding easements, is to understand the difference between an easement and a license. And this can be tricky. A license is a right to use somebody's property, just like an easement is the right to use somebody's property. But a license is for a very, very short term and is revocable, whereas an easement is irrevocable. And a license is something as silly as a theater ticket. The right to be in a theater for 3 hours. That's a right to use the theater seat, is a license. Parking in a parking lot, that's a license, that's not an easement. And as I'm sure you know, if you pay to park in this garage over here, you are using somebody else's property, which is what we said is an easement, but for such a short, limited period of time, and it is revocable, meaning they can close the garage at any time they want to and you don't get to use it again, it's called a license. It can be very hard to distinguish a license from an easement in gross. An easement in gross we talked about is the easement, like a utility easement, that doesn't benefit any certain particular parcel whatsoever. And a license doesn't benefit any particular piece of property whatsoever. A license is strictly a personal right. And the materials say a license is not an interest in land, and it is not transferable, and it is normally revocable. Understand really, if you would, that a license is a term that's used for something much less formal and much less dignified than an easement, and normally would not be recorded. An easement would be recorded. You'd want to record your rights to that piece of that strip. But a license, being such short term, is not. But there seems to be a lot of similarity, and they're always discussed in the same breath, easements and licenses. But licenses maybe are a couple hours or a couple of days, whereas an easement is forever and is irrevocable. And that's really it. Yes, ma'am.
You didn't talk about, for termination of easements, it talks about release, merger, and estoppel. You only talk about
I didn't
merger.
talk about those concepts because, I didn't talk about merger. Merger, we
Merger,
talked
yeah,
about.
that's.
Yeah, we
that's
did.
what
Estoppel, I didn't talk about estoppel. That shows you how important I think it is. Estoppel is the concept, Estoppel has about at least a dozen uses that I can think of in different areas of the law where we use the term estoppel. And estoppel means that you have once taken a position and you are then prohibited in the future from taking a contrary position. Estoppel, as it was used in this context, as I recall it, was you demonstrated conduct you conducted yourself such that it appeared that you were never going to use the easement again. And therefore, I was entitled to rely upon the concept that you weren't going to use the easement anymore. And you are now stopped from coming back and saying, no, I really mean it. I'd like to have my easement again. And that's a pretty silly explanation, but that's about how silly I think the concept is as it applies here to termination of easements.
But the action or statement has to be done by who? The one that's using it, right?
Yeah, the person who is using it had to act as if he was never going to use it again. And then he is therefore stopped from coming back later and asserting, no, I really would like to use it. It's a recorded easement, which is really the type easements we're talking about, would never ever be eliminated in that fashion.
No.
A recorded easement is only going to go away by a recorded release or by a recorded merger. And for that reason, I don't think it has much application.
Okay.
There were a couple others that I thought were kind of silly too. Abandonment is the same thing as estoppel. That means quit using it.
Right.
But again, with a recorded easement, abandonment is never demonstrated in the public records. So the only way you're going to get rid of a recorded easement is by a recorded release or by ownership of both parcels ending up in the same party that's going to kill it by merger. Okay, any other questions? All right, well, I think we're going to finish a little early. Let's talk about next week. end of our class next week, we're gonna have a midterm. It's gonna be pretty short. 45 minutes max, maybe a half hour. Probably 6, 8, 10 questions. As I understand it, Ryan, you and Chad both have to miss a class. Anybody else, everybody else gonna be here for the midterm next week?
Yeah, we'll be here.
Okay. I think what we'll do is this. What I intended to do was to have the midterm cover the 2 chapters that we were going to discuss in class first next Saturday. And that, as I recall, is real estate sales contracts. Contracts in general, and then real estate sales contracts, I think. And I think I'll reverse myself on that, because Ryan and Chad won't have the benefit of being here to hear that lecture. And I don't want you to have to be in a position of then having to watch the tape. What I'm getting at is, the midterm is therefore only going to cover chapters 1 through 9. Stuff we've done through today. We will, in our next class, cover chapters 10 and 11. And those are pretty extensive. Chapter 10 is basic contract law. And we've talked a little bit about basic contracts already when we talked about the lease aspects of being a contract and the basic requirements of entering into a contract. But then more particularly, chapter 11 is a real estate contract. And we're going to discuss concepts that arise in the context of a real estate purchase and sale contract. But then we're also going to go through, I'm going to send you a form commercial sales contract for the purchase and sale of commercial real estate. It's a form done by the Florida Association of Realtors again, but it's a damn good form contract, and a lot of lawyers use it in commercial acquisition deals that are cookie cutter, for lack of a better term. What I mean is, they can be very large deals with big numbers in them, but they're simplistic in the sense of they don't have a lot of overly complicated concepts on them. So my plan is, we'll go through chapter 10 on contracts in general. We'll go through chapter 11 on real estate contracts specifically. We will then go through the discussion of that 8 or 10 page form commercial real estate sale contract. And then we'll have our final exam for the last half hour, 45 minutes of the class. What do you guys want to do in terms of when? Would you like to do it before or after the next class? Would you like to just come in early or stay late the next class and do it then?
Yeah, that's good.
Is that good for you the following week, the following Saturday? You both available then?
Yep.
Okay.
Come in
Would you
early.
rather do it early or want to do it late?
Early's good.
Early.
I'm sorry, early?
Early.
Great. Why don't we get together here at 9?
Perfect.
Is that good?
Mhm.
9 o'clock that day. And then, I'm going to give you the same, after I've written the test, which I haven't done yet, I'm going to give you the same amount of time, obviously, that I'm going to give everybody else. But I don't know what that amount of time is, but it'll be less than an hour.
Okay.
And we'll just go that way. Is that good?
Perfect.
All right. Anybody have any questions on anything in general? Or on the midterm? You've seen kind of the format of the kind of questions I'm going to ask. You know, I'll ask you for 5, 6, 7, 10 lines of what are a couple of concepts, what I mean, contrast them, compare them, things we've talked about in these first 9 chapters. For the purpose of your preparation, you won't be tested on anything that we haven't talked about in class, period. If I didn't think it was important enough to bring it up in class, then I don't think it's important enough for you to have to learn it or to be tested on it. So my point is, review your notes. Look at the textbook to the extent you need to clarify things in your notes, but don't go reading the chapters in the textbook, or else you'll be covering an awful lot of crud that's not going to be on the test. If you have good notes. If you got nothing else, then you got to go to the textbook. But if you got good notes, that's what's going to be on the test. Okay. All right, folks. I'll see you next week. Thank you.
for next week. During the meeting, except for.
No, 'cause I wanted to do something else. Why are you missing?
Not next
No, I want to
Yeah,
start
what are
doing
you
it.
missing?
So, I mean, yeah, I just don't want to have to do, I think it's 20?
Oh,
Well,
20 up to 30 or.
I think it's just 20 in total.
Yeah.
But, I just want to, I mean, there's elevator stuff, you know what I mean, like things like that, stupid things. But then there's other structural things that I would like to go to like the site, and then we'll just put